in the morning, meet with a justice at noon to discuss the procedures of the court, not the substantive issues of the case. If the students have time after this oral argument is completed, Justice Crooks will talk to you about the procedures and answer any of your questions. If you do not have time and have to leave, we understand that, but that decision can be made at the end of this proceeding. If you would like a summary of the case we are about to hear, the Deputy Marshal, Mr. Pond, has summaries. So if you raise your hand, if you wish to get a summary, we can give it to you. All right. I've introduced the students to everyone. Let me introduce the court. Sitting on this case, on my far right is Justice David Prosser. To my immediate right is Justice Ann Walsh Bradley. I'm Shirley Abrahamson, the Chief Justice. To my immediate left is Justice Patrick Crooks, and on the far left is Justice Patience Rogensack. Justices Ziegler and Gableman are not participating in this case. With those introductions made, I will now call 068P 2851, Office of Lawyer Regulation versus Joseph Sommers. Representing himself is Attorney Joseph Sommers. Mr. Sommers, you have 25 minutes, and then if you want to, you have rebuttal for 5. Mr. Sommers, first thing you have to do is stand and appear in front of the microphone, because we record the oral argument should the court want to listen to it, and that microphone also amplifies so that others may hear you.
Your Honor, I was just going to request that I be permitted to go 20 minutes on my direct and 10 minutes on my rebuttal.
Ms. Falk, do you have any objection? That's not the typical. Do you have any objection to that? You may do that, Mr. Sommers, no problem.
Okay.
Mr. Pond, you'll change the light, so at the end of 20 minutes, you will get a red light. At the end of 15, you'll get a yellow. Did I say that properly, Mr. Pond? Okay. Now you should have a green light. Let's do that, shall we? Thank you.
Okay, Attorney Joseph Sommers on his own behalf, if it pleases the court. I would begin with, I think that there are 4 factual propositions that have been overwhelmingly proven that I don't believe any objective, fair-minded person could say otherwise in the face of the overwhelming evidence. First, there was a fraudulent prosecution was commenced against Adam Raisbeck. It was a criminal conspiracy, and it was orchestrated from the Dane County District Attorney's Office, and it utilized an expert in that regard. This conspiracy engaged in putting up perjured testimony, putting up knowingly falsified expert data, and included fraudulent warrants in order to coerce a teenage boy into committing perjury. Second, the misconduct on the part of the Dane County District Attorney's Office was brought in formal motions to the Dane County Circuit Courts. Sworn affidavits were provided to the Dane County Circuit Courts substantiating the misconduct, including conduct which was criminal. Rather than acting in a responsible fashion, the Dane County Courts decided to cover up for what had taken place, to attempt to bully, to intimidate, and to browbeat me into backing off. This even culminated at one point with the trial court under Judge Higginbotham falsifying an order in order to cover up the prosecutorial misconduct that had taken place. 3, OLOR, the Office of Lawyer and Regulation, which has characterized itself as this court's in-house law firm, rather than acting in a responsible fashion, decided itself to cover up for the misconduct on both the Dane County courts and on the Dane County judges. Their actions included falsifying, systematically actually, falsifying the record. It included withholding documents that they were mandated to turn over to what is called the PRC, and it also included them taking off of the table the worst allegations of prosecutorial misconduct, including that which is criminal in regards to their purported investigation of the Dane County District Attorney's Office. It included as well them assigning an attorney to investigate whether or not there had been misconduct on the part of Paul Humphrey, the Dane County prosecutor, which included the subordination of perjury. They assigned an attorney who was then involved in a business relationship with Robert Crimes, who was the individual who was alleged to have committed perjury in this matter, and whom the evidence to him committing perjury has been even acknowledged by a number of individuals, including both Judge Higginbotham and Judge Pakowski. Then we have the fourth factual proposition. Going as far back as September 29th, 2003, there were efforts made by Attorney Sommers to inform this court to what had been taking place. This court, rather than acting upon the information that it has received, including the substantial evidence that has been provided to it, instead has, for whatever reason, stayed its own rules, permitted the Office of Lawyer Regulation to repeatedly engage without any sanction whatsoever in conduct that is objectively misconduct, and in some cases even criminal. This goes so far to what has taken place that it would, I think, in any fair-minded person's mind, be not only most troubling, but would even go so far as to people to say, how can you have legal proceedings in such an atmosphere? How can any fair-minded person not conclude that it is a farce? We have, in regards to this, the conduct in regards that relates to this court, documents were taken not once, but not twice out of my file. They were not misfiled, as this court wanted it to be characterized, but rather that it could be proven by this court's own record index that these documents had been filed correctly. And then after that, again, not once, but not twice, they were taken out. What did these documents show? These documents substantiated, one, the misconduct on the part of the Dane County District Attorney's Office, which again was criminal. Two, these documents substantiated that this court's in-house law firm had knowingly engaged in falsified representations in a systematic way. And these documents were very much similar to the documents that had been originally withheld by this court's in-house law firm from the PRC. Then it gets further. It goes further. Then we have this court appointing a referee who went so far, apparently, to cover up for the misconduct in the Dane County courts and what had taken place in this case, that he inserted a paragraph into his decision which was publicly disseminated, a paragraph which was completely false, a paragraph to make it appear as if the Dane County courts had actually reacted strongly against the prosecutorial misconduct that was shown, when in fact it was the exact opposite. What really had taken place was the exact opposite of what this court's referee put into his decision. And he could not have gotten his facts from the record because they did not exist, which means he made up the whole story. It is possible that he pulled the same facts from an article in the Wisconsin State Journal, but as this court well knows, the Wisconsin State Journal retracted that particular paragraph because, well, it was false. But then it goes on from that. We also have the same referee who was appointed by this court, originally granting me what was called a counterclaim. then prohibiting me from putting evidence on behalf of the counterclaim, and then claiming on the record that he had never granted me a counterclaim, only to reverse himself later on and to admit that he had granted me a counterclaim, only to reverse himself later on to say that he had never done so. All of this captured in transcript pages. All of this proving his dishonest conduct, and yet this court, of course, did nothing. In regards to, as well, into the misconduct that has been shown to this court, my yellow light has already come on.
Yes.
I don't believe I've been up here for more than 10 minutes.
It's been 15 because you started at a quarter of. But go ahead. You've got 15,
Okay.
you've got 5
Anyways,
minutes.
I find that surprising, but okay. In regards to what has taken place with that, this court is in regards to the referee, this court was given on numerous occasions evidence showing that the first count against me was based upon an out-and-out falsification. There can be no doubt at this time that it was a falsification. The Office of Lawyer Regulation claimed to have found in Adam Raisback's court file a subpoena that had been served. Well, of course, as everybody knows, it has never been found. Even the Office of Lawyer Regulation concedes that at this point in time. But that's what set in motion me being charged. That's what set in motion the papers picking it up. That's what set in motion my reputation being destroyed, me being financially destroyed. It's interesting that Judge Prosser was so concerned about what takes place with CCAP, how people's reputations can be destroyed by false allegations to which they are later acquitted or the charges are dropped. But when it comes to me, this court has no concern. It has no concern whatsoever that that took place, and it was orchestrated by this court's very own in-house law firm and its director, something that cannot be honestly disputed by anyone. Just as well, I find myself in front of a tribunal right now who's the son of one of these judges, Justice Crooks' son, has threatened me with being criminally charged, threatened me with civil action, threatened me that to sic Oloar upon me. And for what? Just because I publicly informed the public on a radio show, honestly, on the Mitch Hank show, that Justice Bukowski had conceded under oath that the evidence is that Justice Crooks' son's client committed perjury, lied falsely, on behalf of the Dane County District Attorney's Office. Now, if I think for any fair-minded person, they would be concerned, they would be troubled. Isn't this a conflict of interest? But apparently, there is no concern from this court. We go forward. Everyone else, basically, we have arguments that are in the paper about how this court is worried about this conflict of interest, that conflict of interest in regards to Justice Gableman, Justice Ziegler, who are not even here, apparently for some apparent conflict of interest, but I don't know what that could possibly be. But anyways, these justices are not here. But Justice Crooks is here. And how can that be? And I'll just close up, because apparently this court doesn't have any dispute about the facts that I put forth, which were all basically also included in my brief from page, I think it's 3 to 46.
Mr. Sommers, I'm going to interrupt you for a minute.
Sure.
Because the Deputy Marshal has just indicated to me, you were right. It was a fast 20 because the computer clock was running on fast time. I'm sure you've had that experience sometimes with taxis and their meters. Well, that happened to our meter today. So you have an extra about 5 minutes. Would that be all right? Go ahead. I just wanted you to know
Okay.
that.
Now, what's the bottom line right now? How much time do I have right now? Thank you very much. Okay. In regards to...
Well, I'd like to ask you,
Sure.
you made a comment about me. Are you asked to withdraw from the case?
No, I'm asking you to show me the same level of concern you have expressed publicly. You have acknowledged that false allegations on CCAP, where people are acquitted, where charges are dismissed,